Hello, good evening to you all. I must say we are very sorry for the lateness in the time that we gave to you all. For one or two reasons, we all couldn't expect to hear the presidential speech today, so that's pulled us a little bit back. However, we are back. We are here with you to give you what we have today. Hoping that you would all enjoy it and it will benefit you in our studies. Today, unfortunately, I came alone, so I'm here alone to at least give you what we have. From next week, we'll surely come in pairs. And some of you that you are out there viewing as well, will intermittently be inviting you also on our program for you to come. It's a community that we are building for all of you, and so here is not a matter of only formalities. It's a matter of educating, a matter of giving you informative pieces that you need, and also help you to achieve or to achieve whatever you want to achieve. So yes, today we are here to take you through the initial review of the core courses that we study in the university, that is in the study of the law. And we have divided our initial review into three parts. Today is part one, where we are going to have a review on legal system, a review on the constitutional law, a review on law of contracts, and in our part two, we will come to give you a review of law of torts, a review of criminal law, a review of land law, and then in the final part we'll also tackle the remaining core courses as we study in the university. And after the initial review, then we'll go back, take the courses one by one, and then tackle each of the areas, each of the concepts one by one. Give you the specifics under each of the concepts, give you the cases, give you the authorities, give you the necessary ways that you need to approach those specific areas, and also possible questions that may help you to understand those areas. We would also take that and then go into details for that. So yes, we have a lot of packages for you all. We also hope that you are viewing our other content. There are also parts that those little did you know series and the ones that we give you on the episodes are all there to help you also to complement what we are doing through our live streams for you all. So yes, so we don't have enough time. Let us start because it's already late, so you can sleep early and go to class tomorrow, those who have class. Let us pick our first course. As we say, three courses today. We are looking at legal system, we are looking at constitutional law, and then we are looking at contracts. Because we are doing initial review, you wouldn't expect me to go into details, but at least I'll give you what will help you, so that if you have an interim assessment to write, let's say this week or next week, it will help you adequately for that. And our subsequent ones, we'll take the areas one by one and go into details. So yes, the live session is also open. You can also put down any comments and questions. I will also attend to it after. So let me start quickly with the law of contracts. I will start with contracts, then I'll come to legal system, then I'll end with constitutional law. So with the law of contracts, specifically, let's say by now you've done terms of contracts. That is, I'm talking about the objective tests and the subjective tests. That is terms of agreement. You've also done offer and offer. You've also done acceptance. You've done intention to create legal relations, and probably capacity to contract. All these terms are mentioned specifically from offer, acceptance, intention to create legal relations, and capacity to contract that are mentioned are all elements of a valid contract. In order for a contract to be deemed valid, you need to ensure that the element of offer is present, the element of capacity is present, the element of acceptance, the element of intention to create legal relations, and then consideration. These elements are very necessary for us to get a valid contract. And so these are the terms that I'm mentioning. And so I presume you've done these areas. I'm going to cover from terms of agreement down to capacity, and I'll end for contract review today. And so let us quickly start with objective tests, subjective tests under terms of agreement. Now it appears that when you have a case with somebody, normally you entered a contract with a storekeeper to purchase some bags of rice, and upon the agreement that you entered with the storekeeper, you entered into the terms or the contract with the storekeeper with certain terms that you expect that the storekeeper would comply to, and you would also do your part. Now, terms of agreement, specifically the objective test and the subjective test I'm mentioning here, comes in when there is a dispute between you and then the seller, you the buyer and the seller. When there is a dispute that will come up, or that has come up between the two of you, and you've taken it to court, the question comes: how will the court resolve that dispute? The position of the law is that the court is supposed to look at the objective tests and apply it to the case, not the subjective test. So you have to ask yourself simply, what is the difference between the objective test and the subjective test? The objective test, in simple terms, as I said today, we are doing review, so I wouldn't like to go into details, but the review would help you to understand what you've read. So the objective test, in a simple way to put it, is the judge trying to go into the mind of what the reasonable bystander would think. That is, if somebody with a reasonable mind, a lay person, how would the person think if the person is handling such a matter? That is what the objective test in simple way seeks to paint to you. The subjective test, on the other hand, is about your own mental position, your own intention. The court is not supposed to look at your own intention, your own motive that you had, but it is supposed to look at what a reasonable person will think out of the situation that you are facing. And that is what the law says. The court is supposed to apply the objective test to the issue to resolve the matter. And so over time, the courts have laid down certain principles to govern how the objective test ought to be applied. And so that is what we learned here. And we learned about seven standard objective test principles that, depending on the case that you are having with, let's say, the example I cited, the seller, it will the court will invoke to apply to your instant case. And you know that some of them has to do with ambiguity. When the contract you entered into with the seller, let's say you went to the shop that you want to buy a bag of rice. When you got the bag of rice that you saw were different bags of rice. But the contract that you entered with the seller, you didn't specify. The contract did not specify which specific bag of rice are you buying. And so in that case, the court is supposed to look at the totality of your contract you've entered into, and then look at it and see that, okay, there is an ambiguity in the contract. So the moment the court finds that there is an ambiguity, that is using the objective test to find that there is an ambiguity, automatically the contract will not be deemed to be enforced between the two of you. And so this is one of the 7 tests, ambiguity. On the other hand, when there is no ambiguity, you know what will happen. The court will enforce the contract, because no matter how you entered into the contract, you know that the court is there not to prevent you from what you've consented to do. What you've consented to do, if it is legal, the court is supposed to enforce it. And so when there is no ambiguity, the contract will be deemed valid between you and then the seller or the other person. You know that the common terms to use for this is offer, the offeror, and then the offeree. The offeror has to do with the person who brought up the offer, and then the offeree is the person who accepted. But I will get there when I get to offer and acceptance. So bear with me with the example I'm using with the seller and the buyer in this instance. And so yes, so when you take your question, or when you assume that you have a question at hand, and they are asking you to identify which of the objective tests will be applicable. Let's say it is a problem question. What you're expected to do is to assess all the objective tests, because they want to see that you indeed understand and you know the principles under the objective test. You first of all need to make us aware that the court is supposed to apply the objective test and not the subjective test. And then you lay down the 7 principles under the objective test with their cases, and specifically situate your answer to or your issue under the specific principle that is applicable. And that is how you'll be able to resolve it. Else when you jump to just go straight forward to resolve your issue with the one that is directly applicable, you're on point, but you may not really get enough of the marks, because you need to see that you understand all the principles. But usually the question on objective test or the terms of agreement normally has to do with essay questions, not problem questions. Normally it's essay questions that you come in. So they can ask you to discuss the objective test, and you would have to now discuss all the 7 principles, or they can ask you whether you agree to that and all that. So yes, that is basically about the objective test. But most of the time, the examination questions that comes hinge heavily on the elements of a valid contract, of which I mentioned earlier on: offer, acceptance, intention to create legal relations, capacity, and consideration. Usually, the questions that come, especially the problem questions, they bother much more on these areas. And so, you need to pay much more attention to look at what is the difference between an offer and then invitation to treat. What is the difference between that? Because any question they ask you, you need to distinguish the two if the question borders on offer. So you've read Gibson, you've read NTSC versus entry. These 2 cases are very important, and you saw how Dateba JSC, as he then was, defined what is an offer in NTSC versus entry. One thing you need to understand, the difference between an offer, which is an offer that would end up creating the contract, and then the invitation to treat, is that from the NTSC case we read, an offer must be definite. The terms of the offer must be definite, meaning it must not leave any significant terms open for further negotiations. So what does this tell you? It tells you that an invitation to treat is not definite. An invitation to treat is not definite, but an offer must be definite. And so when you are answering the question, we need to see these key terms for us to know that indeed you know the difference between an offer and invitation to treat. And you don't just have to tell us that an offer must be definite and must not leave any significant terms open for further negotiations. But when you get to the application stage of the question you are handling, you need to demonstrate for us to see that the fact that you are holding, indeed, from A, B, C, D in the fact, it shows that the offer is definite and it does not leave any significant terms open for further negotiation. You would have to identify that in the fact. That is what will give you a plus, and not just by telling us that an offer must be definite. And so that is one key thing you need to identify. When you get the problem question, you will tell us the two: what is an offer, what is an invitation to treat. If the question borders on that, and you raise an issue whether so and so is an offer, you need to make sure that you get us that basic distinction by making us aware the difference between an offer and invitation to treat using the authorities. And so you remember what the Manchester City Council told Gibson, that this letter shouldn't be taken to be a firm mortgage. And then you go to that demand and also look at what's happened in the case, of which he came down to draw the conclusion that an offer must be definite and must not leave any significant terms open for further negotiation. You need to identify the law in that way. And then when you get to the application, you show us whether the contract you are having or the question you are having under the issue you are resolving, is it an offer? If it's an offer, why? Does it lead or does it leave significant terms open or not? you identify that, and that is what will make us aware that you indeed understand the principle, and not just by stating the principle. Before I conclude, I will show you a simple way to write, so that you don't jumble your work when you are writing, especially in a problem question. Earlier on, we sent a video, or we have a video on our channel. You can check it out. That is showing you or how to approach a problem question. So you can look at that also for further way in writing a problem question. Now, under an offer, that huge word, an offer, of which I've said that you need to identify the difference between an offer and invitation to treat. Under invitation to treat, we all understand that we have different types of invitation to treat. And so when they ask you the question they may ask you may fall under one of the invitations to treat. It could be that there is a display of items on a shelf. It could be that it is an advertisement. It could be that it is a circular. It could be that it is a general offer. Any can come in. You know the types of invitation to treat that we have. And so when they ask you the question, and the question also demands that it falls under one of the exceptions, or one of the types of invitation to treat, then you don't have to only distinguish between an offer and invitation to treat. But you need to go further to also make us aware which type of invitation to treat it is. If the question you are going to resolve, the issue you are resolving, it's appearing that the correct answer to that issue will be under an invitation to treat and not an offer. Your first issue could be that it is an invitation to treat. Your second issue, you also find an offer. I will show you how you identify issues, even though it is in the video I've indicated earlier. But essentially, when you have the question and then it appears that there is maybe, let's say, an advertisement, like what's happening in Caleb versus Catholic Smooth Ball, or Patrick and Crittenden, what you need to do is that you identify the difference between offer and invitation to treat, and further make us aware that advertisement is one of the exceptions, or one of the types of invitation to treat. And then you show us which of the authorities, the two authorities or the other authorities that you name, that directly falls under the facts that you are handling, and then you apply it to the question that you are dealing with. So yes, you need to approach it in that way, and then you have a good case. It's not by you just stating the difference using Gibson and NTSC or any other case and then you move on, whilst you know that it demands you to go further to show us which of the types of invitation to treat the person fall under. And additionally, you need to also know that under offer, there are various rules that apply, or various principles that apply to what makes an offer valid to create that contract. And so you need to pay much more attention to the question when they ask you the question. Identify whether there is a lapse of time in the question. What creates lapse of time? You know the common law position. You know the Ghanaian position when it has to do with lapse of time and revocation of a contract. And so you need to look at those lines and see the question. Normally, most of the problem questions they give in contracts, normally they look at that area especially. They will tell you that the contract was made on 1st April 2022. When the contract was made on 1st April, Frederick, who was my guest I brought last week, the offer was made to Frederick last week. Let's say that the offer was made to Frederick last week. Sunday, that the offer was made to him. Now, when the offer was made to him, he is expected to accept the offer as at today. But within that 1 week, something comes up in between. And what comes up is always important for you to identify. What is the effect of what comes up? And what comes up could be that I either revoked the offer I made to Frederick, or Frederick sent to me a certain response, of which that response that Frederick sent, it could be that it is a counter offer, or it could be that it will have an effect of a mere inquiry. And so you need to look at those specific things that come in between the time frame that has been given. And in other words, all what I'm trying to describe to you is that under offer, not all situations that an offer can be made today and accept and what the acceptance is expected within the next second. An offer usually, and from the problem questions that we normally have, an offer would be made as on a certain date, and acceptance would also be expected on a particular date. Normally, we describe that type of offer not in the way people call it open offer, firm offer. Firm offer, it's not called an open offer as we normally used to call it, a firm offer. And so you need to identify whether the contract that has been made is a firm offer or not. And when it is, the things that happen, the events that happen in between are very crucial for you. You are supposed to know what distinguishes a counter offer from a mere inquiry. Normally last week, if you joined us in our live stream, my guest told you all that before you read the principles and before you read the cases, always try to appreciate what you are learning on top of your fingertips, so that when you go and approach the principles and also read the cases and read authorities, it will become much more easier for you to grab. That is why I'm not mentioning the authorities here, because what is important for you to grab today, so that in your week when you are reading, it will help you, is to explain the thing in ordinary way for you. And when you go and sit down and pick the authorities and you read, it will become familiar for you. And so when you pick a counter offer, as I'm saying, that it is one of the events that may happen in between, the counter offer would have to be something that either the words in the counter offer or the words in the response the one I made the offer to is bringing, that words in the response must come to have an effect of revoking or varying the initial offer I made to the person. It must either revoke or it must come to vary the terms of the offer I early on made to him. So it is different from a mere inquiry. And you know a lot, you've seen a lot of examples. You've read hide and range. Critically examine the fact in hide and range, and examine the fact in Stevenson Jack, and you will see. What is always, make sure that under this, when you raise an issue on counter offer and mere inquiry, the facts are very important here. You need to make sure you distinguish the fact very, very well, and then you apply it to the case for us to show that indeed this particular thing that has happened in the case you are handling is a counter offer per the application that you've made, or it's a mere inquiry. So identify the difference between the two in the cases that falls under that, and then you'll be able to appreciate it. And so you need to look at all those things. And at what point in time will you say the offer there was a consideration? Now, of course, you know that in Ghana we've slightly changed the common law position of consideration when it has to do with a counter offer and revocation of offer. Section 8, we all recall that when the person when you make the open offer to a person, you must leave the offer to the end. It is different from that of the common law. So you need to always also make sure that when you're applying the counter offer and looking at it in that way, you raise a different issue on the effect of Section 8 on the contract. And then you'll be able to see it's very, 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 the difference is very slight. And if you're not careful, you'll be confused that there is a counter offer, so automatically the contract is what revoked. No, in our position in Ghana now, the contract is not deemed to be breach or revoked. So you need to look at those things very well. That is, if there is a firm offer, that's what I'm talking about. So that is a brief of what I could say about an offer. I will be able to go into details, as I said. Subsequently, we will take it and go into details and also make you aware of them, because the principles, as we know, have a lot under offer. But essentially, all what I've said under offer is one, note what makes an offer, which is definite and specific terms not open for further negotiations. Distinguish that from invitation to treat. Identify the words that the Manchester City Council used in the Gibson case, and then also look at which type of invitation to treat are you handling in the question they're giving to you. Look at whether the question you are handling is a firm offer or not. If it's a firm offer, the events that happened in between the date the date the offer was made and the date expected for an acceptance to be made, what are the effects of those events on the offer? Does it create a valid contract or not? Look at those events, and that would help you to appreciate an offer. Don't forget also about the standing offer and then a requirement offer and all that. So we'll get into details of all these things. Now let's quickly move on to acceptance. Automatically, I've mentioned acceptance when I was explaining an offer. All what you need to know under acceptance, for brief, is to pay attention to the principles under acceptance. Because the question they normally ask, you can find about 2 or 3 types of acceptance inside the question. Or you may find one particular mode of acceptance that is expected that the offeree, which is the one the offer was made to, should give in response to the offer. It could be either the acceptance is expected to be made by post, that is, you must send your acceptance by post. And so you have to find out what is the effect of the postal rule to the offer if the acceptance is sent by post. At what point in time will we say if the acceptance is sent, it is deemed to be an acceptance? Look at Adams and Lindsay. Read the fact very well. And look at the ruling as well. And also look at other modes of acceptance, like instantaneous mode of communication of an acceptance. Look at Henton and Fraser. Look at Mouse East household, and then look at all the cases falling under that, Henton's as well. And you realize that instantaneous mode of communication, you are supposed to find out where we deem that acceptance was communicated. Is it at the place the acceptance was issued, or at the place the acceptance was received? All that happens under instantaneous mode of communication. And so look at those exceptions. Luckily for us, we have Professor Christine Dona Hammond's book that has neatly summarized the modes of acceptance after the postal rule. And so you need to look at the question they've given to you. Which of the modes of acceptance is the offeror expected? So that when maybe the offeror says, you should send me your response by email, and you, the offeree, you send your response by post, you now find out what is the effect of the post that the person sent. Because mind you, the law says when there is a prescribed mode of acceptance in the offer, the offeree is bound to use that mode unless that mode is practically not going to be possible to be used. And so you're supposed to find out, was it practically possible for that mode to be used, which is the email? If it was, then you apply the case that falls under that. If it doesn't, then you also apply what is necessary. So you must always look at the effects of it, whether the postal rule that the person used, is it indeed reasonable for the person to use it or not, when there has been a prescribed mode of acceptance. But mind you, the general rule in law, we have the general rule and we have the exceptions, and it applies a lot in contract law. The general rule, we must identify the general rule. Note this clearly before I forget. At any point in time you are solving a question and you see a general rule and you also see exceptions, please raise the general rule first before you go and then talk about the exceptions. If the exceptions is what that is applicable to your case, don't jump and just go and talk about the exceptions. We want to see that you know the general rule before you are going to talk about the exceptions. So as I said, the general rule says when there is a prescribed mode of acceptance, you are bound to use it. So you are supposed to make us aware that that is it. Now you go and apply as to whether it is the exceptions that apply to the case you are handling, depending on the fact, or it is the general rule that applies. So please pay attention to the various modes, because they normally pop up in the examination. You always find themselves in a certain hidden corner. So always identify whether there is a prescribed mode of acceptance, or which of the modes of acceptance the offer expected, or which of the mode of acceptance the offeree used, and the effects of that mode. and that will determine whether there is a valid contract or not. Quickly, I'm left with two principles or two elements, and I'll be done with contracts. And the next element I'm going to state is intention to create legal relations. I think that is pretty much more simple. Before I go there, please don't forget that under acceptance, we have silence as a mode of acceptance. You need to also note whether silence as a mode of acceptance is deemed to be valid. Generally, silence is not deemed to be valid as a mode of acceptance. It is not. So you need to note that as well. So now quickly, you need to also understand that the element of intention to create legal relations, normally they separate it from a question on offer and acceptance. You can take the past questions, you can also take your course outlines if you have them, and you realize that the questions on offer and acceptance are different from that under intention to create legal relations. It's so voluminous if they combine the two. So they always separate it. So please, don't be confused. When you see a question on intention to create legal relations or intention to create legal obligations, do not raise a question on offer. Do not raise an issue on offer and acceptance. That is presumed to be there. An offer is presumed to be there already. It's presumed that it has been satisfied. Acceptance is presumed to have been satisfied. Now the question comes, is there any intention to create legal relations between the parties, even though there's an offer? That is why we have basically two types, the social setting and the commercial setting. So I enter into a contract with, let's say, I enter into a contract with Frederick, who is a very good friend of mine. When we entered into the contract was that Frederick should take me out this coming Easter, so that I will go to the Agri Plains or the Crapping Plains to stay at the Mediasi Lodge for the weekend. That is the offer. That is the contract we entered into. Frederick accepted. I made the offer. Frederick said, okay, he's going to take me there. Now it has gotten to the Easter, which is next 3 weeks coming, God willing. And when he got there, Frederick disappointed me. Frederick rather went out with one or two parties of his, and I was in my room dressed up nicely, waiting for Frederick to come and take me out to the Crapping Plains. Unfortunately, he couldn't come. So now when there is an issue here, Frederick has breached the contract. So you see that here, the person will not have to do it won't bother about whether there is an offer or acceptance. That is already there. The question that will now come before the court will be whether the contract I entered with Frederick, is there any intention to create legal obligation between the two of us or not? That is what the court will look at. But the court will not look at whether there is an offer or acceptance. And so, if you look at it, the court will look at the contract. Did we provide any term inside the contract that says expressly or by impliedly there is an intention to create legal obligation between the two of us? If the court finds so, then the court will find Frederick liable. But most of the time, because Frederick is a friend, very, very good person, also closer to me 24/7, it is most likely that it was just a social agreement that we had. And so automatically, you know the principle that where the agreement that was entered into was a social setting or was a social agreement, there is no intention to create legal obligation between the parties. So you need to note this principle very clearly and note the relationship between the two parties. What will make you identify whether there is the setting creates obligation or not is first, identify the relationship between the two parties that entered into the agreement. Second, identify whether the contract they've given to you or the terms of the contract they've given to you provides expressly or by impliedly any term that seeks to pin the two parties under legal obligation. This is what will help you to know whether it is a social setting or not. But note, as I said, you need to state the general rule before you go to the exceptions. And the general rule under certain social setting is that there is no intention to create legal obligations. But when you think the exception applies, by looking at the express terms and the implied terms of the contract, then you go further to pin them down. So look at the cases that falls under that, and you'll be able to identify it very well. And the other ambit of intention to create legal obligation comes to domestic affairs. But the other ambit is the commercial setting. The commercial setting, in simple terms, is the opposite of the social setting. I enter into a contract with Standard Chartered Bank. The contract we entered is that I need a loan from them. They give me the loan. The time comes for me to pay the loan. And I must say, Standard Chartered Bank has a very good loan packages to people. So it's good for me to use them as an example. So they gave me the term. The term was really, really, really beneficial, that I should pay the loan within 50 days. The time comes, I've not paid. The interest has accrued on it. I've not also paid the interest. So an issue comes. The court will not go and bother at all to find out whether there is not an intention to create legal obligation. What the law said is that where it is a commercial setting, there is an intention to create legal obligation. Unless the parties provide otherwise. That is the opposite of social setting. Social setting, there is no intention to create legal obligation. Commercial setting, there is intention to create legal obligation. Social setting, the parties can provide that it should create legal obligation. Commercial setting, the parties can provide that it shouldn't create legal obligations. So get the differences. Commercial setting is the opposite of social setting. The last thing under intention to create legal obligations is that we have the domestic affairs. Social setting is not only about friends. It also has to do with domestic affairs. And you know that under the law, generally the questions they ask falls under 3 types of domestic affairs. 1, married couples, people that have married. What is the effect if they enter into a contract or an agreement? The law generally says it's not binding because there is no legal obligations. Unless there is a problem like separation, divorce, and those things. Look at buffer and buffer and merit and identify the difference. And then the second type of social domestic setting under the social setting has to do with a parent and then the child. Find the position as well. Look at the Panavatin case and look at the position as well in that. Then the last one has to do with people living in a domestic environment. They live at the same place, that is one home, but they are not indeed connected by way of relative or parent-child. They are not connected. What is the effect of that also on them? Look at that. And you'll be able to know the question that they give to you. If you understand it in this way, I've broken it down. When they give you the question, all what you need is that remember your authorities and apply them. The last is capacity to contract. Capacity to contract is also voluminous as how offer is voluminous and as how consideration is voluminous. But essentially what you need to note is that under capacity, Ghana, our position is that unless you are at a specific type of age, 21 years, you are not supposed to have capacity to enter into a valid contract. This is the general rule that we all know. In UK that we adopted this from the common law, they've changed their position, but in Ghana we still hold on to the general rule that 21 years. So you need to identify. This is the general rule. State it. The question they ask you, the capacity of the child. Will you just pin the person down and say the person does not have capacity, so the contract is not binding on the child, who is the minor in this case? Or the question and you will pin the person down that it is binding on the minor. Before you pin the person down that it is binding on the minor, then it means that you are looking at the exceptions to the 21 years age. Although you may not be 21 years, but the law provides that there are certain circumstances that a minor will enter into a contract. That contract will be binding on you. And in other words, we call it voidable. It is not. It's not void. There are some of those contracts that the minor has entered into the agreement, but the court will not look at it to be void. The court will look at it to be voidable, means you can take steps to repudiate it. And you know them. You know almost all those examples. But normally, the court look at it whether the contract you've entered into, the minor has entered into, is it a contract for necessary? Always provide the definition for necessary. If the question they've asked you falls under necessary, provide the definition of for necessary. Look at the Sale of Good Acts for the definition of necessary in Ghana, and then look at the common law cases also under that. Nash and Aman, and then Chadwick and look at all those cases under it. But section the Sale of Goods Act at 137 should also help you in the Ghanaian position. Look at the definition of necessary. Does it apply? If it applies, indeed, then you pin the minor down, although he or she may not be 21 years. Look at whether the contract is onerous or not. That is, if it's a contract for training, education, trade. Look at those terms. Is it onerous or beneficial to the child? If it is, it will be binding. And then that is for minors. Under capacity, it doesn't only apply, it's not only borders about minors. It also looks at persons that are intoxicated. What is the position of the law for persons that are intoxicated when they enter into contracts? You look at all those classes of capacity or classes of persons that the law provided for their capacity to contract under that element, and then you pick when the person comes in line with it and apply. And also, normally people don't pay attention to contract when somebody has entered into a share purchase of shares of a company, purchase of lease, as well. Look at those things. Currently in Ghana, at first, before Act 992, that's the Companies Act, when you purchase a share and you are a minor that is below the age of 21 years, that will not be binding on the minor. But currently the law has changed from Act 992. Look at section 12 of Act 992. When you are 18 years, you can be a member of a company. So you can purchase shares in Ghana now. When you purchase a lease or when you go for a loan, let's say this student's loan especially, the legal position is also slightly different. Because it is loan, student loan and those kind of things, the law is slightly favoring the person granting the loan. And so you look at the position of the law very well, and when the question is given to you, you pick and apply it to it very well. So that is all I can say for now about contracts. So when you go to an examination, mind you, questions on capacity will also be different. They won't ask you anything on offer and acceptance over there. It will be too voluminous for you. So they will give you the questions separately. So raise the questions only in respect to that particular element you are dealing with, using the principles. Normally, the trick is that in contracts, when you want to identify the issues, every sentence you read generally should give you a hint of an issue. Every sentence you read generally should give you a hint of an issue, especially under offer and acceptance. And also an invitation to intention to create legal relations. You are not normally, it doesn't demand you to raise a whole lot of issues. Very few, maybe 2 or 3 issues over there, not like offer that can give you about 12 issues. So you look at those things very, very carefully and you raise the issues necessarily. Don't raise the issue as you see it. Don't bother to solve and go and come back. Raise the issue as you see, because raising the issues give you marks, even if you are unable to solve all of them. But raising all the issues before you come and pick them one by one and resolve gives you marks. And so look at it critically. Sometimes the test you write may also be in true or false, or maybe in A, B, C, D. And in that case, you need to read the principles very well so that you'll be able to know which of them, if they ask you the principles very well, and it demands you to say true or false or A, B, C, D, you pick them out. But normally in examination, you will write, you will resolve problems. So look at once again, our video on how to solve a problem question, and then you will see all these things. Let me now move on to our second course, which is legal system, and I'll end with constitutional law. Now, legal system, I'm also going to tackle very few. I won't go into detail because it's very broad. I can use just few minutes as we have on our hand here to tackle everything. But as I've promised you, we'll come and take the areas one by one under these courses and deal with them drastically for you. But for general view of legal method and how to learn legal system, legal system, normally you need to have your background, your historical background needs to be okay. I won't say it should be strong, but make your mind ready to appreciate the history. We are not expecting you to use the history to resolve your problems, but what the history does is that it helps you to appreciate the current situation of our legal system. So when you are resolving, you get to know where we are and where we are not. That is why they sometimes teach you topics like legal traditions, introduction of British jurisdiction. They don't teach you for just teaching's sake. It helps you to appreciate the legal system that we have and what actually exists in our legal system at this moment. So at least have a general idea of the history, and then have a general idea of the current legal system we practice. When you've been able to read, when you've read your constitution very well, it will not be difficult for you. The constitution is the Bible of the law. So you read it very well and get used to it. And so, legal system, under legal traditions, you need to understand that there are differences between legal systems and legal traditions. Legal systems are, for want of better words, the babies of legal traditions. Legal systems are the broader umbrella, or they are the broader families that we are able to create legal systems out of them. So every country has their own legal system. Ghana, we have our own legal system. Every country, US have their own. France, they have their own. Now, so all these legal systems created by every country on their own created that legal system they practice, or the legal system Ghana we practice from a particular legal tradition. So meaning the legal systems, you can find more than 100, but legal traditions, you get there are few. And the notable legal traditions that we know are common law, civil law, social, and then the African, the Islamic as well. These are the common ones that we know. There are lots, but these are the common ones for purposes of your exams. And usually, those that you need to pay much more attention for purposes of examination is common law, civil law, and to some extent the socialist law or the social law. But if you pay much more attention to the common law and civil law, at least you've done 80% of the tax under legal traditions. What you need to do under this topic is make sure you create a table to help you understand. Create a table in your notes. And then on the left side, let it be civil law. The right side, let it be common law. And identify one, which people are the legal personnel under the civil law, which people are the legal personnel under the common law. List them under them. 2, also identify under the civil law, how do they train their lawyers and their judges? How do they get them? The lawyers and the judges. How are they gotten? How are they gotten? What is the training? What is the school? What is the legal education that is given to the lawyers and then the judges under civil law? You put it under that. You come to common law, you do the same thing for common law. That is the second thing you need to know. Then the third thing you need to know under civil law is what are the features of the common law legal tradition. What are the features? You know that one of the features of the common law legal tradition is that the judges are inquisitorial. So you come to common law under the same heading, noting the features of the common law. You know that the judges are adversarial, or the court system are what? The courts are adversarial. But civil law, they are inquisitorial. I mean, they are supposed to also investigate the judges. They are supposed to investigate the matter before them. But for common law, the judges are adversarial. They just have to sit down, listen, and apply the law. And so you note the difference, the features. This is just one of the features I've given you. And then you also know that under civil law, one of the features is that a lawyer does not rise up automatically to become a judge, but you need to go through a certain process of schooling. But the common law, a lawyer can just rise up to become even a Supreme Court judge. And we saw typical example happening under this current government, where our own Professor Mensa Bonsu, JSC, currently in the Supreme Court, was a lecturer at the University of Ghana and was appointed by His Excellency Nana Dankwa Akufo-Addo to the Supreme Court. We also saw Kolendi JSC being a practitioner, a lawyer, who was also appointed by His Lordship to the Supreme Court. Same applies to a lot of lawyers. That is for common law, but you can't do that in civil law. So you note the difference, the features, and that would help you. To some extent, you can also add the fourth element, which is the sources of the two systems. What are the sources of common law? What are the sources of civil law? You will say there are differences. So in a sense, four features: the personalities or the personnel under the two system. Look at the features under the two system. Look at the sources under the two system, and then look at the mode of the legal education, or the mode of which they get their practitioners and their judges under the two system. When you are able to do these distinctions clearly, it will help you. And another thing I need to note is the history between the two. What was the evolution, or how was the evolution of the civil law? Note that and see where it started to the time it got to where the codes that they were doing, or the laws that they were doing, were codified or kept into codes. And when they were placed into codes, which particular book, or I want to use that common term, so I'm going to details in that way. So help me and pardon me with my words. Which kind of book that they place all those laws inside to become a common code. And so you shouldn't forget the Justinian Pandect and all those processes that went through under civil law, for which the civil law tradition evolved. Don't forget the medieval universities that also picked it up at a certain point that they ended up teaching. Don't forget all those things. And mind you, civil law countries are many. We have Germany, France, Italy as some of the examples of the civil law country. And then you come to common law. Common law legal tradition. Look at the history. Divide the history into three. We have the development of common law. That is after the Norman Conquest in 1066. That is when we started seeing the feudalism gradually develop to become the common law. And what gave us the common law is the stare decisis. It starts from there. So the time we had the race system. So now you move. After that, when you get to the race system, you will now come to the next stage or next phase of the common law development, which is where we got what is meant by the equity or doctrines of equity, or where we had the equity as another branch of the common law. And you start that from the problems that the rates system gave us. Identify those problems. That is when the equity began. To the time, I wouldn't bombard you with a lot of the names of the judges, but note some of the names of the judges from the 15th century, 14th century, and the 16th century to the 18th century that had impacts in the development of the common law. Right away from the Oxford case, you look at all those things that the judges, the influence that they had. For which reason we had the common law, and then look at the common words that some of them use, like the equity varies according to the length of the chancellor's foot. And look at those common things and the effects of it that created. Then you move to the third phase of the development of common law, which is the fusion of the two, where Maitland made us to understand that the two are together, but their waters never mix. The two streams are together, but their waters never mix. When did that start? It started from 1874, after the passage of the Dedicator Act. So the two came together to give us one system of common law. So we trace the history, give us the salient things under the history of the two. And that would help you easily to identify. So create the table and do the differences. And it will help you to appreciate the two systems. So that any question they ask you on any of the two, you should be able to handle. Usually they will ask you any of the characteristics, the distinctions, or give us the advantages, the disadvantages, or tell us the history. So you look at those areas and then see. Then the next is classification. I won't talk much more on classification because we have a video on our channel that we've given you on classification of law. We've given a breakdown on that topic where we're able to identify, try to give you a breakdown of the branches of classification of law that we could have. Mind you, everybody can classify law according to what they want to achieve, or the interest they are looking at, or the information they want to put out. But generally, you need to note that we have the international law branch, the municipal law branch. When you go under the municipal law branch, we can also further break it down into civil and then what? Criminal. When you pick the civil, we have the public civil and the private civil. The public civil has to do with constitutional law, the administrative law, and then the tax law. That is, public civil has to do with, it is not criminal, but the state is involved in the action. That is one clear distinction that you'll be able to make. And then you now look at the private civil. Under the private civil, you know them, the contracts, the tax, immovable property, and all that have you. So look at those specific branches and their characteristics as well. Then you generally come and look at the importance of classification. When you go and view the video on classification, we gave you how you should classify or how you should group the importance of classification. What we made you to understand that classify them according to groupings. The importance of classification to lecturers or the teaching of the law. Importance of classification to the study of the law or to students. That to practitioners. That to adjudication or to judges. And all that, group them accordingly. And you have a very good work representation, because classification of law benefits each of the classes or each of the groupings on a separate level. And I remember one of you asked me, what are the connections that you can get between classification and the various branches of classification? It's so simple. You pick substantive law and then you pick adjectival law. What do you see? What is the connection that you can get between the two? Will you be able to get any connection? If yes, you do so. Let's see example. Substantive law and then law of contracts. What do you see? What is the connection? It's like relationship. Substantive law gives you some kind of connection to contract because they have something in common. What substantive law gives us the rights, tells us the rights and privileges and the responsibilities imposed on a party or a party is entitled to. Same applies to contracts. So once you be able to find some connection over there, then you find a disconnection between substantive law and adjectival law. Substantive law deals with the rights and entitling somebody who is entitled to certain rights. Procedural law is not about rights. Nobody has a right under procedural law. Nobody has a right under procedural law. That is what the law says. So you need to comply to procedure. The procedure says A, B, C, D. Do this before you will be entitled to this. So that's a disconnection. So you need to find the connection and the disconnection between the various branches of law. Just pick them. The easy way to get them is that where a certain type of law falls under a certain branch, automatically it will have a connection with that branch. Where the law falls outside that branch, though there may be some connection, but the disconnection may be high because it is because they fall outside that branch. That is why they are not connected. But there will be some slight connection if you want to find them. So that is essential. So look at the video on classification and you'll get the details of it. Now the next thing is also on introduction of British jurisdiction into Gold Coast. that one as well, there is a video, comprehensive video, that through the good article that was reviewed by our own Dr. Bassett Abdul Aziz, who lectures at the University of Ghana, we were able to provide a very brief events and effects of the events, or the legal effects of those events under introduction of British jurisdiction. It's on the channel. So you also look at the third lesson of the Ghana legal system, which is on the channel, and then look at that video. It gives you the comprehensive events. So this is what you need to understand. Under the topic introduction of British jurisdiction, 1, identify the effects, the events, and then the effects of those events on our legal system. That is the first you need to know. What are the events? And in identifying the events, you need to note that those events happen at a particular point in time. So what are those years? Identify the years that those events happened. And then the legal effects of those events on our legal system. 2, the overall introduction of British jurisdiction into the Gold Coast. What effects does it have on our legal system? You need to also identify that. Specifically, they may ask you even in specific that what effect does it have on our court system. They can also ask you what effect does it have on the entire legal system, or what effect will you identify it on our traditional chieftaincy system. They can ask you in any how they want to ask you. But if you're able to identify the effects and the events, you will be able to answer the question very well. So look at that video, and then the questions also under that video. Try your hands on the questions under that video, and you see how that those questions cover generally everything under the introduction of British jurisdiction. But a little thing I want to point out under this, let me just give the salient dates or the salient years that when you are reading on introduction of British jurisdiction, pay attention to the event that happened in those years, and then look at the effects of the event that happened in those years on our legal system. So 1, look at 1821. 2, 1828. 3, 1830. 4, 1842 to 1843. 5, 1844. 6, from 1845 to 1853. Let me pause at 6 and give a little bit of breakdown again. In 1821 was the time that, you remember the famous West African Act. Look at the effects of that. That was also the time that they placed us under Sierra Leone. So the central government was at Sierra Leone. Look at the effect of that. 1828, look at what happened. The merchants and the committee of merchant. Look at all those effects. 1830, when Maclean came, the peace treaty. And then the famous declaration by Maclean, which also led, the famous declaration by Maclean was around the 1834, which made the British to eventually decide to ratify or rationalize the relationship that they have with us, so that it will have a force of law. That led them to 1842, 1843, the Parliamentary Select Committee decision that they made. When you pick the effects that the event that happened in 1842, 1843, which is the Parliamentary Select Committee, look at, they can ask you a question on that alone. To what extent were the recommendations by the Parliamentary Select Committee implemented? So look at them. Which of them did they implement early? Which of them did they implement later? Which of them they didn't implement at all? Look at that. That is the event that happened in 1842, 1843. 1844, the bond of 1844. A person can come alone on that one by asking you what are the clauses in the bond, the 3 clauses. Discuss the 3 clauses. And then because it has to discuss the effects of the clause and the repugnancy clause under the bond on our customary law. So they can ask you a whole lot of questions. So look at the bond, there are 3 clauses of the bond. Look at it critically under 1844. Don't look at it in the eyes of the history. That's I'm pointing out these specific things that you should look at it when you're reading the bond and those effects. Then you look at the way that people patronized the court system from 1845 down to 1853. They didn't have jurisdiction on a lot of cases, but our people patronized it a lot. Look at the effects that made us to get the court system that we encouraged them to give us the Supreme Court that they gave us in 1853, which currently we are now practicing the Western way of resolving issues. It started from that angle. Look at the effects. Look at the first Supreme Court we had and the jurisdiction of the Supreme Court in relation to the High Court of Admiralty in 1853. Look at that. And then look at what happened in 1865. Then the next one also, you need to look at what happened in 1872 down to 1876. You remember that if it was history that we were doing, somebody could have mentioned the Street Waiver Convention. You remember that's where the British had an agreement with the Danes. But in law, you don't need the Street Waiver Convention around that period. It's not relevant for us. What we need is that just move on and tell us that it was the end of seeing that those kind of war between the Ashantis and the British, and eventually 1873 we saw the Judicature Act, which 1874 24th of July, when the war ended on 24th of July, we also had the Judicature Act that was passed. So look at the effects of the Judicature Act of 1874. And it is very, very important that Judicature Act of 1874 it still exists as of today. That is what we call the General Statute of Application. If you've not averted your mind to that, the Judicature Act that we normally refer that we saw in the introduction of British jurisdiction is what we currently call it, under our laws, the General Statute of Application. Is part of it. Essentially, what the Judicature Act was doing is to make us understand that all laws that existed before 1874, that is the common law, are applicable in Ghana. But laws after 1874, that date, 24th July, is not applicable. They are not applicable in Ghana unless we choose to pass it into law in the country for it to be binding on us. That is why we have common law. So what gave us the common law under Article 11 of the Constitution is the Revocation Act. So look at it very critically. That is one of the effects that you can see. And so look at it. I'll just give you a hint of one of the effects, how you'll be able to connect the events to the current act or the current situation in our country. Then look at the Supreme Court Ordinance of 1876. Look at the clauses under the ordinance, the repugnancy clauses, the structure of the courts, the qualifications of the judges, the jurisdiction of the various courts, compared to our court system today. Because they can ask you a question on that alone for you to compare to our court system today. So look at that as well. And then you look at the judicial assessors arguments that came in 1878, and then gradually the native courts ordinance as well that was repealed and later on passed in 1927 and all that. Look at all those events. These are some of the very important years that you need to pay attention to and make it reflect in exams or in your questions that they will ask you. And so that is what essentially I could say for now on the introduction of British jurisdiction. But the video gives you further details of most of these years, but supplement it with the little bit of the explanation I've given, especially looking at 1842-43. Before you understand what happened in 1842-43, you need to note the effect of the peace treaty that Maclean entered into in 1830 and the declaration Maclean made in 1834 thereabouts on the mentality that the British were having as if they were colonizing us or as if they thought they had dominion over us, which led to the Parliamentary Select Committee report. The extent of that report. Look at the bond of 1844. Look at the first Supreme Court of 1853. Look at the Judicature Act and the effects it is having now on us. Look at the Supreme Court ordinance and the native court ordinances and all that. And you see that you can be able to do a better appreciation of introduction of British jurisdiction comparing to what is happening today in the country. The last thing under legal system is the court system. Since that one I wouldn't go into detail because it's a broad topic. That one, you will look at the history of the court system. You will look at the jurisdictions of the courts. You look at the hierarchical arrangement of the court. You look at the personnel of the court. That is how the judges are appointed, their term of office, and all that under the court system. So that one is broad. So I wouldn't tackle that on that. But all what I'll say under that is that we'll come into details on that topic. But essentially, what you need to note is that before you understand the court system, you trace it from the Supreme Court Ordinance of 1876. You trace it from that same area. That is where you'll be able to understand the court system we have today. Trace it from that area. Look at the court system we had under the first constitution, under the Republican Constitution, the Supreme Court and the High Court. Later on, under coup d'etat era, we had the full bench of the Court of Appeal serving as the highest court. But under the Supreme Court, under the civilian government, we have the Supreme Court operating as the highest court of the land. Look at those petty things. Which year did we have the full bench? Which year did we have the Supreme Court? And what was the structure of the court system during all this era till now? What is the court structure? You will see that the court structure clearly stipulated under Article 126 of the Constitution today. But before you understand the court structure under Article 126 of the Constitution today, and before you'll be able to understand the powers vested in the court under Article 125 of the Constitution, trace it from the Supreme Court Ordinance, look at the history, and you'll be able to appreciate it. So that is what I could say about the court system for now, because as I said, there are a lot of subheadings under this topic, of which we would have to have a special video or program or show for it. Now, the last thing I want to tackle, so far so good, is constitutional law. You've done so good to come this far. I hope you are having a good time with me over here in the studies, and those who are not able to join, you also share it to them. Let them all come and subscribe, watch it, and also learn. We have a lot that we'll be bringing to you as time goes on. We are still building a lot for the betterment of all of you. And mind you, we are open. You put your comments at the comment section all the time. We'll always respond. You send us an email, we'll respond. This live program we are having today initially was not part of our plan to have it today, but next week. But because we listen to our cherished subscribers and our cherished viewers, the recommendation became a lot. So we needed to organize this for you all. That is why we are here to give you this special review today, other than starting next week that we plan off. So we hope it will benefit you as you move on. So let me quickly end up with constitutional law today. First, I won't tackle definition of constitution and then supremacy of the constitution, because we've also done a special video, lesson 1 tutorial, first tutorial lesson on constitutional law. It's part of the videos on our channel, so you kindly scroll through our playlists, the law playlist, and then you'll find that video and watch. Under that video, the only thing I could say is that we gave you the structure. When you want to define the constitution, what should you do first? When you pick the constitution and then you want to talk about it, what should you do? Always have it at the back of the mind that any person they ask you on the definition of constitution, they need you to provide what somebody has said, critique what the person has said, or write a critique by discussing what the person has said, as whether it is broad, narrow, whether it has the various elements, the effect of it. Then give your own conclusion as well with your own definition. So you look at how we gave you the structure under that video, and then the cases that we also gave you under that video that supports that topic, and then the various writers as well. We went on to even give you sources of constitution, and I don't think most of you have done sources of law now, but the sources of constitution are different from the sources of law. They are different. The sources of constitution are gotten from past constitutions, history of the country, constitutions of other countries and all that. But sources of law are specified, like the sources of law in Ghana are seen under Article 11. So they are different. So we gave you the sources of law of a constitution we give it the features of a constitution, and then we move on to tackle supremacy of the constitution. We separated, or we gave the distinction between supremacy of the constitution and supremacy of parliament. So read Riakoto. That case is very important for constitutional law. Read Riakoto. Identify the difference between supremacy of the constitution, supremacy of parliament, sovereignty of parliament from that case, and then you'll be able to appreciate that topic as well. And so let me quickly move on to look at municipal law and international law under constitutional law. This topic, if you are in level 100, you will meet it again under public international law in level 200. But essentially, for brief of the topic, all what you need to note is that the law seeks to make you understand that under international law, they has to do with it is about the various treaties, conventions, and agreements that exist on the international plane that governs countries, the relationship between countries. Municipal law has to do with the laws applicable in the country alone. So Ghana, our municipal laws start from the Constitution. What the Constitution does, it's only applicable to us and not outsiders, unless they come in contact with something we are doing inside our country here. You understand it from that angle, and then it will help you to appreciate the difference between international law and municipal law. It's not any difficult topic, so I wouldn't like to go into details, else I'll end up taking it further to look at the monist approach of international law and municipal law, the dualist approach of international law and municipal law. But I think it's not something difficult, and also what is meant by translation and incorporation of international. When we get into the details of this area, we'll tackle these terms relating to international and municipal law. The translation of laws under municipal law, and the incorporation of laws under municipal law, and then the difference between dualists and then the monists. We'll look at these things when we are tackling this topic eventually. Now, let me move on to look at separation of powers, and I'll do coup d'etat, and I'll do rule of law, then we'll end for today. As I said, these are not only the areas. In contracts, I left out consideration, I left out terms of contracts, I left out other areas. We would eventually tackle them when we are doing the specifics. The same applies to legal system. Contract and constitutional law too, same applies. Else we will not be able to end. So pardon us for such short breaks. But these we believe will help you for now to appreciate. Because when you get the beginning, the continuation always is connected to the beginning. So for separation of powers, all what you need to understand is that there are various arms of government that exist in a country. These various arms of government are supposed to function in a manner that will benefit the entirety of the operation and the governance of the country. And so there is a certain concept called separation of powers. It is not a principle, it is a concept called separation of powers. It is not a doctrine, it is a concept. In law, it is a concept called separation of powers. This concept comes in to equip the government or the organs of government to operate effectively. And so they need to be separate from each other. That is what you need to appreciate and understand. The concept comes in to make the government operate from each other separately. And so what you need to note is that there are two approaches or two views under separation of powers. Whether the watertight approach of separation of powers or the flexible approach of separation of powers. So they may ask you to discuss these two, or they may ask you a problem question relating to Ghana, and you are supposed to find out whether the Ghana's separation of powers is watertight or flexible. We had this watertight and flexible approaches from the concepts, the development of the concepts and cases. Now, in order to appreciate the watertight and flexible approach I'm talking about, see what Baron de Montesquieu said about separation of powers. identify the types of the types of organs of parliament under the types of organs of government under his definition of separation of powers, and note the problem with his definition of separation of powers, whether it achieves watertight or flexible as well. Then you do the same for John Locke. What are the types of organs of government under his definition? Identify whether it is watertight or flexible, and the problem with his definition. Which country is it situated with? That would help you to appreciate the watertight and then the flexible. The watertight has to do with the situation, for instance, where government, a typical example could be where we had in the 1979 Constitution of Ghana. The executive arm of government was totally separated from Parliament or the legislature. The members of the executive arm of government were taken outside the legislature. That is an example of watertight. So when you are a member of Parliament and you are appointed to become a minister, automatically you vacate that seat. So you no longer serve as a member of Parliament, but you rather become a minister of state or a minister of the country under the executive arm of government. So we had that under our 1979 Constitution, where the executive was separated from Parliament, and that gave us a lot of problems. And so that is what made us to decide that, okay, we are not going to practice that watertight under the 1992 Constitution. So we gave some proportion that majority of the executive should come from Parliament, and then minority may come outside Parliament. That is what you see under Article 78 of the 1992 Constitution today. But initially, all members were coming outside. So in that instance, you can see that it is flexible. Our Constitution today makes it flexible in that example that I have cited. So you need to look at it in that way. Watertight means they are too separated. They don't deal with each other. Their functions don't deal with each other. Separated. All what they can do is that they check on each other. But their functions are separated. The members are separated. But flexible could mean where they intertwine, but they still perform their function. So look at John Locke's, compare John Locke's definition of separation of powers to Baron de Montesquieu. Then after you do that, you also come and look at the cases that is supporting the watertight and flexible and the definition of separation of powers and the effect of separation of powers. Look at what Justice Soa said in 24 verse Attorney General. We've neatly also provided what Justice Soa and what Justice Akins said in 24 verse Attorney General and then MPP versus Attorney General, the 31st December case respectively. In one of our Did You Know episode, check the Did You Know episode 7. And see when we're talking about the effects or the meaning of or what the 1992 Constitution represents. See the two cases displayed there. You'll be able to find some of the key words relating to separation of powers in that definition that the two justices gave in the two cases I've mentioned. And so you will identify what they said over there and look at it. What is the effect of what they are saying to separation of powers? And the famous quote of or the famous words of Soa that what happens in Parliament is a closed book, or all what happens in Parliament are closed book, meaning that you are not supposed to open it. And so much, fortunately, you also have to contrast that decision that was given in Soa to look at the political question in J.H. Mensah and then the current ruling of the Supreme Court when it just last 2 weeks when they ruled on whether the Deputy Speaker of Parliament should be counted when it has to do with voting in Parliament, and then the Speaker is presiding, the Deputy Speaker is presiding. They also decided political doctrine or political question in that ruling in the current case to what went on in J.H. Mensah on political question. And you will find out that to some extent, though Parliament, the matters that happen in Parliament is a closed book, But there are certain circumstances that the court will open and enter into what happens in Parliament. Look at the current ruling, as I've mentioned, the judgment by Kolendi in that case, and Kolendi GSC in that case, and then you'll be able to appreciate what I'm talking about. So look at what the justices said in ND Attorney General, the defense December case, to forward the Attorney General, J.H. Mensah, and then the current Supreme Court ruling. Unfortunately, I don't have the title on top of my head here. But if you remember what I've said, it was about the Deputy Speaker and the challenge of the Deputy Speaker, whether the Deputy Speaker has the right to vote in Parliament when presiding as a Speaker of Parliament, and Article 102 of the Constitution. So look at the ruling of the Supreme Court and then compare to the political question, look at separation of powers from that angle. And then you also look at the international cases. Mind you, for separation of powers in Ghana, don't also forget Riakoto. Riakoto works in almost everywhere. So you can't forget about Riakoto. Everywhere you find Riakoto. But for the outside cases, that's also it's very important for you to look at. Look at Nixon versus US or Nixon versus Sirica. Look at what happened over there. See the ruling, pay attention to the argument of Nixon, and look at what the Supreme Court and look at what the judge said with respect to the argument of Nixon, and you get to see whether what the judges were saying, what Nixon was saying, whether they practice flexible or they support flexible or watertight. Look at all those areas, and then look at what the decision of the Supreme Court also in the Youngstown Sheet case. Look at it very well, especially look at the judgment of the 3 justices. Pay particular attention to Justice Jackson. And if I'm you, I would quote what Jackson said. If I'm solving a question, Justice Jackson, I'll quote what he said in separation of powers. It's one of the powerful quotes under separation of powers. So please, if you can chew it, it's not that hard, because we all learned it when we were there. We all chewed the quotes, used it very well. Don't just chew it and go and write. Chew it, make sure when you're writing, you explain it very well in respect to separation of powers. Watertight, flexible, and the effect of separation of powers on the governance. Look at it very well. Justice Jackson's quote in Youngstown Sheet case. So these are some of the things that you need to look at it under separation of powers. Eventually, we'll go into details of it, as I've said. Under constitutionalism, which is another aspect that falls under constitutional law, generally has to do with 3 elements. Constitutionality has to do with institutionalism or limitations placed on institutions. It also looks at substantive, that is the substantive law restrictions that is placed, and then the procedural restriction that is also placed. So you look at all these elements. These are key elements under constitutionalism. That when you pick them, you look at it one by one. What are the substantive limitations constitutionalism places on governance or on the various arms of government? You pick, that's where you do the comparison. Pick executive and then legislature. Find the substantive limitations. Pick executive, judiciary, do same. Judiciary, legislature, do same. And then you'll be able to identify the substantive limitations each of the arms of government have on each other, the institutional limitations, and then the procedural limitations. The procedural limitation on Parliament, example is Article 106 of the Constitution, which has to do with how they make law. Another procedural limitation on institutional limitation on Parliament has to do with when they pass law under 102, who signs? The President. See Article 106 of the Constitution. See also the institutional limitation that is placed on the executive when they appoint a Chief Justice or Justice of the Supreme Court. The Parliament serves as limitation on them, so they need to come for vetting. Look at the appointment of justices under Article 144 of the Constitution. Look at the removal of justice under 146. They all serve as institutional limitations, and sometimes also go further to serve as substantive limitations. So look at those things under constitutionalism. When they ask questions on constitutionalism, normally they are looking at you to display these elements. Then look at it to display these elements and look at it, compare it to the various arms of government and see how they serve as limitations on each other. Because constitutionalism has to do with limitations. Constitutionalism has to do with limitations. And so look at it in that way. And rule of law, and I'll end on coup d'etat. Rule of law, essentially, two things you need to look at. First, the proponents of rule of law, that is those who have written, those who are the people that we normally refer to when we talk about rule of law. Once again, remember, separation of powers is a concept, constitutionalism is a concept, rule of law is a concept under law. So what the rule of law, the two people that we normally refer to, A.V. Dicey and Ivor Jennings. So look at what A.V. Dicey said about rule of law. Look at the elements of rule of law from A.V. Dicey's position on rule of law. Compare it to that of Ivor Jennings and find out what Ivor Jennings also said. It appears it's almost like a slight opposite of what A.V. Dicey said. Look at it very well. And don't forget the famous thing about equality, the argument on equality that the two of them had, as to whether all persons are equal or there must be equal among equals. Look at the two positions by the two people, the argument that they had. It helps you to appreciate rule of law because the central element of rule of law is equality. The central element of rule of law is equality. So look at it very well from the two people. Then now come to the second ambit of rule of law. What normally you need to also do. Find out the various elements under rule of law. I want to use elements or requirements to make you properly appreciate because law students are normally used to those words. But what are the various elements that makes rule of law efficient? You look at example like equality is one of the elements of rule of law. Every rule of law, there must be that element of equality. So let's come to Ghana. We practice rule of law here. How will you be able to see one of the elements I've mentioned, equality? Where will you find equality in our law? Article 17 of the Constitution and the Supreme Court ruling. Gatti versus Natti. Compare the ruling of Gatti and look at the ruling of Natti versus Gatti. Look at that ruling, compare it to what A.V. Dicey and Ivor Jennings said and see which of them is the Supreme Court of Ghana supporting in that case. And look at Article 17 as well of the Constitution for equality. The next element under rule of law, certainty. Certainty, meaning the law must be certain. Everybody must know what at least the law says. Certainty. Certainty. And so the Constitution provides for certainty. And clearly you can even see that because we want certainty, everybody must know what the law says. And Article 19 of 5 of the Constitution, when there is no crime or when there is no law making an act an offense, you can't arrest somebody and say the person has committed an offense. For certainty's sake, the law says there has to be an act passed by Parliament prescribing a certain act to be an offense. For certainty's sake. So see Article 19.5 and Article 19.11 especially as examples of clauses that helps you to understand certainty. And look at the case of Chachuchikata versus the Republic, Modipo Okran, as well how they display certainty and predictability in that case. Then I prefer giving you the Ghanaian cases because it helps you a lot. Though don't forget the foreign case of Associated Provincial Picture House case and then the Minister of Civil Servants case as well. They all help. And then the INRI-M cases as well. They all help. So don't nullify those cases. They can even ask you a question alone on those cases because they are very, very crucial under rule of law. But normally people don't pay attention also to the Ghanaian cases. That's why I'm mentioning the Ghanaian cases to supplement those outside cases. So I've mentioned Gatti versus Dati for equality. I've mentioned Nati versus Gatti I've mentioned Chachuchikata case as well for certainty and predictability. Another element and a rule of law that you need to also look at it is or has to do with human rights. There has to be the provision of human rights as well. So look at it in that way because rule of law has to do with human rights. And that is where you even find that currently if the New Delhi Declaration on Human Rights, the civil and civil rights civil rights and all that are coming to play. See chapter 6 of the Constitution for example of the New Delhi types of right, the New Delhi Declaration of 1958. Look at those types of rights. It's encapsulated in our Constitution. Chapter 6 of the Constitution provides some of those rights. And so look at the human rights. We indeed have human rights also under chapter 5. So look at those things, and then they will help you to appreciate and see that the 33rd December case as well for that. So look at the element. There are various elements and the rule of law. I'm giving you 3. There are lots. So you look at it and pick and then attach the cases to it. Identify whether they are practiced in Ghana under our Constitution, and the foreign cases that are on it. What are the propositions? Look at Rich and Baldwin. Look at Associated Provincial Picture House case. Look at the Minister of Civil Servants case. Look at the Inri M case, and the Ghanaian cases of Chachu, Gate, then the 33rd December case, and a whole lot of cases under rule of law, even including Revocation. So please look at these things, and they will help you very, very well. And I would always prefer students reading Revocation from G and G other than the GLR. So that is a little bit of personal advice. It's the reading from the G and G helps you much more, in my view. So try it and see. And the last thing I want to say is that, and the rule of law is that we have a difference between rules of law and rule of law. Rules of law is where the law has provided for rules. Do this, do that, don't do this, don't do that. Rule of law goes beyond rules of law. Rule of law is about whether those elements that we are talking about exist under your laws or under the legal system or under the Constitution that you practice. Whether there are those elements existing to promote rule of law or to promote orderliness in the country with respect to laws. So get the difference between the two and read all the authorities, including A.B. Dicey, Jennings, and all that as well. Now the last, which will be done, it will be coup d'etat and constitutional revolution. Coup d'etat and constitutional revolution keenly look at. I'm giving you basically 3 write-ups that you should look at. Look at Kelsen on coup d'etat. Look at his position on coup d'etat. Look at the rebuttal or the counter or the different opinion or the contrasting view by Phyllis as well. And then read the K.A. Buzier's radio commentary on the AG versus Salah case. K.A. Buzier's radio commentary on the AG Salah's case or AG versus Salah case, and see what rule of law and coup d'etat and constitutional revolution is. According to Kelsen, note the key things over there. There has to be a grand norm. That grand norm, that grand norm must exist, and there has to be the law currently in existence must be traced to that grand norm. And currently, when there is a coup d'etat, for us to say that there is a revolution and so the grand norm still exists, that coup d'etat must have a force of law, which is efficacious. It must be effective. That element of efficacy must exist. So you look at all those things, because they can give you a problem question where you will see that people demonstrated, and eventually they stop demonstrating. So you are supposed to identify whether it has had a force of law, which is by Kelsen, efficacy has set in or not, and whether there is a grand norm and all that. If you look at those things, contrast it with Phyllis, where Phyllis gave us 3 things that must be satisfied: succession, rules to rules. Look at the various aspects and compare. When you take succession, compare to what Kelsen is saying. When you take rules to rules, compare. And then when you take his last element, which I've a little bit forgotten from on top of my head because I'm not referring to any book, so I'll not be able to record everything. But there are 3: succession and rules to rules. So look at, and then the last one is competence. Look at these 3 elements from Phyllis, and then see how these by Phyllis compared to Kelsen. They now move on and come to the state of Ghana. How these 2 people, which of them, or which of them apply to Ghana? When we had our first coup d'etat, the position from Salah case. Did we follow Kelsen or Finis? The position after Salah. You look at all those things. And so, look at the cases that falls under that. I'm happy to tell you one thing, though, that when you take Salah versus Attorney General, because it is different from AG versus Salah. So get the difference. Salah versus Attorney General that I'm referring to over here has to do with, I want you to look at the justices, the 4 judges that wrote their judgments separately in that case. Read the 4 judges, see what each of them said about coup d'etat and the effects of coup d'etat and constitutional revolution, and situate it under one of the 3 or one of the two people, Finis and Kelsen. Read what the 3 of them said and have what the 4 of them said, 3 majority and the other minority. Read what they said and then make a note out of it. It will help you to appreciate Salah as Attorney General. So when you are answering coup d'etat question and you mention Salah, don't say the court said this. Identify which particular judge are you referring to, because they all said different things that you can connect to any of the 2 writers on coup d'etat and constitutional revolution. You also look at Lakami case, the Nigerian case on coup d'etat and constitutional revolution. But one of the key things under the Lakami case that you shouldn't also forget is the doctrine of necessity. What time do we say it is not coup d'etat, but it's the doctrine of the necessity? Look at it in that case. You will be able to appreciate it very well. And then the Majimamuto case, my favorite case as well. And then the ex parte Matuvo. At least when you are able to read these 4 cases very well, you are good to go. And so read all these cases, and there was a case in 1990 as well in Ghana, I think Pia or something like that. So read all these cases on coup d'etat and compare it to the decision and to the 2 writers on coup d'etat, and also read Article 3 of the Constitution to see our position currently about coup d'etat in Ghana, whether it is indeed possible for coup d'etat to happen or not. Look at it. Look at how we've structurized our Article 3 and see how very difficult it is for somebody to now plot a coup in this country. We are totally against coup, and the Constitution of giving you powers under Article 3. So you look at it very well, and then you'll be able to appreciate coup d'etat. Later on, as I said, we'll pick the writers one by one, go into details, apply the cases to them as well, and then you'll be able to appreciate coup d'etat more. But with this, you should be able to get a general overview, so when you pick whatever that you are going to do, you'll be able to answer them. Constitutional law, normally they ask you problem questions on coup d'etat, usually. Sometimes too, they will ask you problem questions on separation of powers. But most of it, separation of powers, constitutionalism, rule of law, nature and scope of constitutional law, those areas has to do with essay type questions. But once in a while, the problem question will come. Coup d'etat, normally it has to do with problem questions. So you look at it in those areas and you resolve them accordingly. Please go and follow the video once again on how to resolve a problem question, and you'll be able to enjoy it very well. So that is what we have for you today. So that is what we have for you today. Let me give a summary of all what we've done, and then I'll end our discussion for today. In the part 1 of initial review of the various core courses in the university that we've done today, we tackled contract, we tackled constitutional law, and we tackled legal system in our part 1. Under contracts, I took you through that under objective test. You need to look at the objective test as the proper mode the court apply to cases. In some of the circumstances, the court will go inside to look at the subjective test by looking at the intention of the party to apply to the case. But normally, the court applies the objective test. So look at the 7 principles generally under the objective test, and at what point in time they operate. I also took you through offer, where I made you to understand that we have the difference between offer and invitation to treat. Definite as a keyword, not leaving any term, special terms or certain term open for further negotiations. Distinguish it from what was said in Gibson. And also sometimes the question will ask you, demands you to identify situate the problem question under a particular type of invitation to treat. You do so using the various cases that falls under it to do that. Then I took you to look at the situation where we have a firm offer, where a firm offer normally people used to call it open offer. Look at the various events that happen in between. At what point in time is acceptance deemed to be a proper acceptance under a firm offer? At what point in time will we say a response from the offeree is a counter offer or is a mere inquiry? And I indicated that read the fact very well under height and range, and then Stevenson jog, and see the contrasting view on that. Then you would also do acceptance. I said acceptance about unqualified terms. The acceptance must be an unqualified terms, unconditional, to in the response to the offer made to you by the offeror. And so I made you to understand that when you look at it in this way, identify which particular mode of acceptance is it permissible under the offer that was made. Which particular mode of acceptance? There are several modes of acceptance, where the mode can be prescribed, where it's not prescribed. Postal rule, and instantaneous mode of communication, and the whole of silence as a mode of acceptance, electronic mode. Look at all those events. Then look at revocation of offer. At what point in time is an offer deemed to be revoked? Don't forget Article Section 8 of the Contract Act at 25. Don't also forget to read the common law position. Normally you state the common law position, where there's a common law position but has been changed in Ghana, states the common law position first. That's as common law, then you tell her what it is. Then you come, however, in Ghana, always make sure that every principle you state should be on a distinct line. As common law, the common law said this: come to a fresh line, states what the Ghana position is. Come to a fresh line, support it with the case that you want to support it with. Always let it be on a distinct line, so that to make your work much more decently arranged. And when they are looking for certain principles, certain authorities, they know that it is on a line, a separate line for proper identification. Don't join them. If you join them, then make sure that you are highlighting your titles and all what you need to highlight very well for us to see it clearly. Then I made mention of intention to create legal obligations, where I said usually they will not ask you a question of offer and acceptance in those type of questions. So you only have to identify issues under that. And I said we have the social setting, the commercial setting. The social setting is the opposite of the commercial setting. Social setting, there is no intention generally, unless the parties expressly or impliedly provide. Commercial setting, there is, unless the party expressly or impliedly provide that there is not. And we have the domestic setting also under social setting, where we have marriage couple. We also have parents and the child. We also have people living, but they are not really related by blood or by any relation, but they are under a domestic setting, all falling under the social setting. We moved on to look at capacity to contract, where I told you to look at the age as a general rule and look at the exceptions. The exceptions comes in the instances where there is a problem as to whether the contract the minor entered in is a necessity or a necessary. And I said look at the Sale of Goods Act 137 for definition of necessary in Ghana. Look at Nash and Inman, and then the various cases that falls under that. And then same applies to if it's a contract for trade, contract for employment, contract for education. Look at the terms, harsh and onerous. Is it harsh and onerous? Look at the cases that falls under all those areas. Then I move to legal method, which I made you aware that you look at the video we provided on classification of law, and I only added a few things to it. That under classification of law, that if you want to determine the connection and the disconnection, the first easiest way to know is that the connection, the various branches that falls under, the various types of laws that falls under a particular branch means that they have some connection with that branch. Those falls under the outside the branch means that they have largely disconnection with other branches. So look at it in that aspect and identify the various connection and disconnection. And we watch the video on classification of law on our legal system episodes. Then same applies to introduction of British jurisdiction. Look at the video on that as well on our legal system episodes. And I provided that particularly pay attention to the various years I mentioned early on. 1844 bond, 1842-43 parliamentary select committee, the Supreme Court of 1853 and their jurisdiction, the Supreme Court Ordinance of 1876, the Judicature Act of 1874. Look at all those things and other things that I said in relation to that. I moved on to also look at that I advise you that to understand civil law and common law, create a table. On the left hand side should be civil law, right hand side should be common law. Identify the history, break them down. The history of civil law, the history of common law. Come to the personnel of civil law, personnel of common law. Come to the features of common law, features of civil law. Come to the sources of civil law, the sources of common law. Identify them separately, and you'll be able to do that. So when you go back, you'll remember all the examples I cited and how I broke some of the history down for you to appreciate. And we moved on to constitutional law, where I said you should watch the tutorial lesson we gave on the first topic of constitutional law, which is the nature and scope of constitutional law, and the supremacy of the constitution, and then what? Parliamentary supremacy. And I advise you to read Riakoto case for supremacy of parliament, sovereignty of parliament, constitutional supremacy. Don't forget the 31st December case as well for that topic. We moved on, and I also advise you that you should be able to grab as much as possible, make it part of your fingertips, or let it be on your fingertips, the dictum by Justice Jackson in the Youngstown sheet under separation of powers. And when you're analyzing separation of powers, look at it in the view of watertight, flexible, the effect of separation of powers on each of the arms of government, and in collective way, how the separation of powers affects them. Then I said look at Baron de Montesquieu compared to John Locke. Under rule of law, I made mention of Ivor Jennings, A.B. Dicey, where I also said look at the argument on equality between the two people, and look at the elements of rule of law and common law, and mix the Ghanaian cases with the foreign cases that you see. I mentioned some of the Ghanaian cases to support some of the foreign cases that we are commonly known for. And I said constitutionalism, we look at it is pure about limitations. The limitations the various arms of government imposes on each other. We look at that, and then lastly I made mention of coup d'etat as well. And I said read the commentary, K. Boozer's commentary on the decision in AG versus Attorney General, which is a different case from Salah versus Attorney General. And then read Phoenix, read Kelson, and then read all the 4 justices' decision in Salah versus Attorney General. And then identify doctrine of necessity in Lankami, and then read Matuvo, read Majimbamutu, and then read Article 3 of the 1992 Constitution, and you will be fine for coup d'etat, constitutional revocation. So viewers, I would end here. Initially, we will come again to do a live stream for you. Subsequently, we'll also be doing videos without having live stream, but to be posted. You'll see people on this, very able people on this channel having a discussion. We'll eventually be bringing some of you on the channel to also have an engagement. We are open to also listen to whatever that you have. We'll come out to respond to them. And we also encourage you that you share the video to people, encourage them to watch, subscribe, write your comments, and like all our videos. Kindly don't forget to watch our Did You Know series. Watch our videos that we provided on the law, because they help us to make everything easier over here. And subsequently also the Did You Know series as we've done to help everybody, not only lawyers or not only law students. We have special content that we are very soon going to launch to also help and educate the wider populace in the country on their rights and responsibilities and other things outside, but a little bit related to the law. That will benefit everybody that is interested to learn. Thank you very much. Enjoy your new week, and then the new month will be entering this week. Have a wonderful day. Thank you and goodbye.